Hello.
We are live, you can start.
Okay. अच्छा, ठीक. Okay. Thank you.
Khushbu?
Yes, sir. Welcome everyone. Thank you for joining us for today's webinar. My name is Khushbu Chaudhary and I'm a student member of the Society for Advanced Research and Analysis of Labor Laws, better known as SARAL. Under the patronage of Bharati Vidyapeeth deemed to be University New Law College and our Dean and Principal in charge, Dr. Ujjwala Bindale Madam, we would like to present our webinar on unfair labor practices in India. Before we commence, I'd like to ask Bindale ma'am to say a few words.
Thank you, Khushbu. So, good evening, everyone. I, on behalf of Bharati Vidyapeeth deemed to be University Pune, welcome Advocate Dr. Shrikant Malegaonkar sir, Advocate High Court and Labour and Industrial Courts Pune. Welcome, sir. Sir, I'm here to formally introduce you to Bharati Vidyapeeth, but I know you don't require that introduction because you know Bharati Vidyapeeth very well. But just to make you aware of what Bharati Vidyapeeth has really done for the students, I'm just going to give the formal introduction to you. The institutions of Bharati Vidyapeeth are accorded deemed university status in 1996 for its academic excellence. So, Bharati Vidyapeeth deemed to be university has established academic excellence and offers programs in innovative and emerging areas. It presently has 29 constituent institutions and it includes 3 research institutes dedicated exclusively to research. It has multi-campus and multidisciplinary campuses and is catering to the needs of urban and rural students. It has significant achievements in its research area. It has world-class infrastructure and facilities. It has launched several innovative academic programs. It has best teaching learning processes and has entered into national as well as international collaborations. All this has been possible only because of Honorable Dr. Patangrao Kadam Saheb, the founder of Bharati Vidyapeeth deemed to be university, a visionary who, at the age of 20 years, decided to establish Bharati Vidyapeeth as a distinct educational institution. Today, Dr. Patangrao Kadam Saheb is the guiding star for the whole of Bharati Vidyapeeth fraternity. So, under the visionary guidance of our beloved patrons, like Professor Dr. Shivaji Rao Kadam Sir, the Chancellor of Bharati Vidyapeeth deemed to be University, Dr. Vishwajit Kadam Sir, Pro Vice Chancellor of Bharati Vidyapeeth, Member AICT, and Honorable State Minister, Social Justice and Special Assistance Department, along with Professor Dr. Manikrao Salunke Sir, Vice Chancellor Bharati Vidyapeeth deemed to be University. The New Law College has been consistently ranked amongst top law institutes of India by Career 360. The Week, the Lawyers Collective, India Today, Education Post, and Outlook. New Law College has been re-accredited A+ grade by NAC and has also received Gold Star Award from BCI on the eve of its Golden Jubilee celebrations. The best practices we follow at our institutions are international collaborations, innovative interdisciplinary programs, international placements, continuous legal education, clinical legal education, social justice through free legal aid, efficient qualified faculty with PhD and NetSet qualifications. And so, to keep up with our New Law College academic excellence, today's webinar has been organized by the Society for Advanced Research and Analysis of Labor Laws, SARAL, which is coordinated by Dr. Jayashree Khandare Madam and Rahi Alat Ma'am. So, the core aim and goal of SARAL is to create a collaborative learning atmosphere that will adapt to the changing concepts of labor laws. It also aims to strengthen and enhance the teaching and research in labor code by conducting different lecture series, encouraging the students to write articles and blogs. SARAL also aims to provide a dynamic and collaborative learning space, both physically and virtually, to learn more about labor laws. So today, I really welcome you wholeheartedly, sir, to this particular webinar. And with all your wishes and blessings, I'm sure Saral will prosper and fulfill all its goals. Once again, I welcome you, sir. And I really thank you, sir. And I express my gratitude towards you, sir, for consenting and to enlightening our students. Thank you so much, sir. Thank you, everyone. Khushbu.
Thank you, ma'am. Moving on, it's a great pleasure for me to introduce our speaker for today, Advocate Dr. Shrikant Maligaonkar, who is going to talk to us about how the unfair labor practices have affected the national as well as global economy. Our speaker is a Samajshri Award winning lawyer who specializes in labor laws and employment disputes. Sir is a specialist in labor laws and is practicing advocate at Pune Labor Court and at Bombay High Court for the past 28 years. He has delivered lectures at various international institutions regarding labor laws and is also associated with companies like Mercedes, Philips, General Motors, as well as hotels like Westin and Radisson Blue, among various others, as their advocate and labor management consultant. Sir has also authored various books and produced serials relating to labor laws. And today we are honored to hear from him. So without further ado, let's begin with our webinar. Please, sir.
Thank you, Madam Dr. Ujwala Bindale, Principal, New Law College, and also Khushbu for that wonderful introduction of mine. It is already 5:10 and I begin. The time which is allotted to me is an hour, and we are going to have 15 minutes for the questions and answers. What am I going to talk about today? And that is unfair labor practices on the part of employers. There is going to be a slideshow, and I'm going to show you slides wherein the unfair labor practices are depicted. But before I jump onto that, let me tell you something. Basically, India after 1947, we ushered into an era wherein Pandit Jawaharlal Nehru, the first Prime Minister of India, had an aristocratic bent of mind. Pakistan and India became independent almost at the same time, but as you know, we are miles ahead than Pakistan, especially as far as industrialization is concerned. However, with industrialization, there came up so many issues. First and foremost, in 1947, we had a central legislation which was passed, which is called as the Industrial Disputes Act 1947. Under the Industrial Disputes Act, a reference is made to the Labor Industrial Code. So it's to happen that suppose your friend, for example, is a worker and he is dismissed. And under the frame of the Industrial Disputes Act, he used to approach the labor office as per the appropriate government and then meet a person called as the conciliation officer. The conciliation officer used to call the management, then the worker, hold a series of meetings, and in all sorts of disputes which are existing or they are apprehended, ultimately after a series of meetings, they used to come down to some conclusion. There could be a settlement, there could not be a settlement. If at all there was a settlement, it was registered under Section 2P of the Industrial Disputes Act. If there was no settlement, then the matter, a failure report was passed. A failure report was then referred to. I mean, what the government will do with the failure report. So it used to refer the dispute to the labor court. Now, this is the usual path under the Industrial Disputes Act. Practically speaking, the time which was taken for a worker who was dismissed, from the point of his dismissal till the time the matter just reached the labor court was something 6 to 8 months. A month here and there, plus minus, sometimes perhaps it could be more also. Now, here the worker is dismissed. His basic problem is what is he going to eat? Would he be having 2 square meals a day? And he is already on the roads. Now, sensing a situation and taking many other lessons from different foreign legislations, the government of Maharashtra enacted an act which is called as the Maharashtra Recognition of Trade Unions and Prevention of Unfair Labor Practices Act 1971. Now, as it indicates, Maharashtra stands for State of Maharashtra, so it is a state act. Let me tell you, friends, in those days, I mean, those days in the sense since 1947, when the First 5-year plan was laid down, second 5-year plan, industries came up. And I mean, it was a bit oxymoronic in those days to say that there were an honest employer. How could both be possible? So it was an oxymoron. It went on for a good deal of time. And then slowly and slowly, India also started getting rich with labor legislations as far as labor disputes and as far as solving of labor disputes. But then, as I told you, this time difference was too heavy. 1 day is okay, 2 days are okay, 10 months, 1 year is taken to just to reach the labor court. So Maharashtra government in 1971 enacted this legislation. And let me tell you, friends, the success of this legislation is so high that it also prompted the central government. Because if you see, Industrial Disputes Act 1947 is a central piece of legislation. It prompted the central government to add all these unfair labor practices to the Industrial Disputes Act, and that is why Schedule 5 was introduced in the Industrial Disputes Act. I'll make it very simple. Today I'm going to talk. My topic is unfair labor practices on the part of employers. There are different unfair labor practices on the part of unions also, which is not our topic of study, because you see what has happened is in 1 hour I am to comprehend everything, which is too lesser time. And then there are case laws and this and that. And to be very frank with you, I am rightly perplexed right now as to which case law should I tell you and which not to tell you. But then we are going to see that a holistic approach, totality of the situation, everybody understands in whatever are the unfair labor practices on the part of employers in the stipulated time. Now, a second, please, and I will be sharing some slides. I'll just do the slide sharing. Yeah. And I hope everybody can. I hope everybody can see the slides. Okay. Now you see unfair labor practices. This is myself, that is Advocate Dr. Shrikant Malegaonkar. Now you see unfair labor practices. This what you are seeing is Schedule 4 of the Maharashtra Recognition of Trade Unions and Prevention of Unfair Labor Practices Act. And the same is the schedule, that is Schedule 5 of the Industrial Disputes Act 1947. Why I'm saying this is there are so many participants, there are so many students, HR managers who are seeing this program from every nook and corner of India, just to tell you that all the unfair labor practices remain the same. So let's begin, friends. As I told you, my time is really limited. General unfair labor practices on the part of employers to discharge or dismiss employees. Now, what is a discharge and what is a dismissal? Basically, these two words have to be clear. A discharge is a simple discharge wherein a person goes out of service, but in a dismissal, a stigma is attached to a person. He is discharged from service is one thing, and he is dismissed from service is altogether another thing, because in both the instances, a person moves out of service. This is the common factor. But in a dismissal, a stigma is attached to a person. And then there are people in India, if he is removed from one company or other, if he is dismissed from one company, everybody has to have 2 square meals a day. So he goes from one company to another in search of a job. And in India, history is very important. They ask him, where were you earlier? And I was in such and such a company. So why did you leave that company? No, I did not leave. I was dismissed. Dismissed for what? Show me the papers. And then he has committed a theft or absenteeism or rude behavior and riotous behavior and this and that, so many misconducts. And the next company says, Namaste, you better see some other company. And it's not that very easy to get an employee for a dismissed employee. Discharge is, in a way, a softer version, I will say, without the stigma. That yes, in both the cases, a person is discharged. Both are dishonorable, remember, friends. But discharge may not be as dishonorable as that of a dismissal. Dismissal, of course, is on a higher pedestal. Now I come down. Now, how do you discharge and dismiss employees so as to constitute an unfair labor practice? First is by way of victimization. What is victimization? Victimization is making a person a scapegoat, or to put it in the vernacular, a balika bakra. We all know that for in India is very fond of all such things, wherein there are so many places in India, in every nook and corner, that some bakra is taken and then he is sacrificed. The sacrificial goat. And there's not a single person who is attending this webinar, including myself, who has never been victimized in our life. We all have been victimized in our life. So many instances I can give you. But then, as far as our subject is concerned, how do you victimize a person? Make a person a scapegoat? I'll give you a very simple example very quickly. Otherwise, I'll have to go through the depths of that example. Say, for example, there was a watchman, and then sometimes you see, you like a person for no reason, and you hate a person for no reason. And the managing director somehow started spewing hate as far as this person was concerned. And he told the managers, come on, I don't want to see his face again. Jo bhi hai, isko dismiss kar do. And then ultimately that watchman was dismissed. What will the watchman do? He started begging, went from pillar to post, sir, maaf karo, galti ho gayi, whatever. Maybe a poor person. And then he used to stay in the village nearby. But the managing director was adamant, and then they drew him out. He went, where do you go? Ultimately, he went to a lawyer's office. From the lawyer's office, the matter reached the court. It's not that easy as it appears. When a person goes to a lawyer's office, he has to keep something there. And then only the papers are going to move. Yes. And what will a poor person as a watchman do with all these things? But ultimately, there was no other way. Matter reached the labor court. Management, for 3 months, they did not file a written statement only. Written statement is the answer to the complaint which is made by the watchman in the labor court. And 3 months, 3 days is a reasonable time which almost everybody gets in the labor court, unless an order of no WS, that is, you don't want to file the reply itself, is passed. And then 3 months were over. Ultimately, the management, the matter came up for hearing on the interim application. Management said that we don't know why this person thinks he is terminated from his services. We are in fact surprised. Why is he not reporting on duty? The judge was very surprised. They looked at the worker, they looked at the management, and they said that if he wants a job and you have not terminated him, why don't you take him back? Management said no problem. Other managers started whispering here and there. I mean, they were a bit restless. I mean, what's happening? Because we don't want this person in our company. Why? Answer is very simple. Managing director does not like his face. Now, whether this could be a reason or not, but as I told you, sometimes you spew hate. You hate a person. Then what they did is they made him come to the company, sign a piece of document that yes, I have reinstated you, because there should not be things like contempt of court. The moment he was reinstated, all paperwork was over. Next day they called him and said that yes, you stay here in the nearby village and the company is here, but there is a sister concern which is 50 kilometers from here. And you are a watchman, but there is nothing to be watched here. What's the duty of a watchman? And there is something, the safe and everything is all valuables of the company. They are in that company, which is that branch, which is a sister concern. So they issued him a transfer order. And the answer is that you get up at 4 o'clock in the morning. By 6 o'clock, you will be at a central bus station. From there, you change your bus. Then at 8 o'clock, you will be at the sister concern. Start working. 12 hours would be your duty. From the sister concern, you will again come to the central bus station by 10 o'clock in the evening. At night, I would say. And from there, again at 12 o'clock, you will be in your house. And I get up in the morning at 4 o'clock. Only 4 hours of sleep. Now this itself is victimization. This is torture. This is harassment. And then what? He did it for 15 days and ultimately challenged the transfer. That the transfer is a malified one. Malified is an antonym of bona fide. And the transfer is a malified transfer and is passed under the guise of following a management policy, which itself is an unfair labor practice. Matter reached the court. Industrial court. These matters, remember, as we are passing through it, item number 1 is triable by the labor court. Rest of the items are triable by the industrial court. Industrial court, just got wild at the management. This is nonsense. Why are you transferring this person? Management, yes, there was a gallery show. A flowery argument was done by the lawyer. Ultimately, the matter was dismissed. Dismissed in the sense against the management. Then what does the management do? When an industrial court passes an order, there is no appeal. When there is no appeal, the writ petition lies under Article 227 of the Constitution. So the management went and filed up a writ petition before the single judge of the Bombay High Court. What about this person? First and foremost, he is a watchman. What could be his pay packet? 12,000 rupees. And then there are a series of cases being filed, layers and layers here and there of appeals also. Ultimately, the matter is in the High Court. Fees of a lawyer in the High Court, going to Bombay, staying in Bombay, all requires money, and this is victimization, this is harassment. And this, if indulged into by any employer, amounts to an unfair labor practice. And not only there, things don't stop here. Sometimes, I mean, if at all the petition before the single judge is dismissed, then people prefer a letters patent appeal. And finally, they even go travel up to the Supreme Court in Delhi by way of a special leave petition. Remember, friends, everything requires money. And what about the mental trauma? What about the mental headache, harassment? And moreover, a very simple question is, what is he going to eat? 2 square meals a day. From where would he bring it? This is victimization. So first is to dismiss or discharge employees by way of victimization itself is an unfair labor practice. You see, all these poor people, they have always found themselves in the rhetorical line of fire of all unions. What is it to do? And then some people are appalled as to how the management is behaving. And yes, victimization is an unfair labor practice. Second, that is B, not in good faith, but in the colorable exercise of the employer's right. Now, what is good faith? There's a maxim in torts that is res ispa loquitur. Res ispa loquitur is the maxim which we see. And the thing speaks for itself. What does the maxim mean? Thing speaks for itself. Not in good faith. What is not in good faith? I'll give you a simple example just to break the monotony of labor laws and the example which I am giving you. In England, there was an old case wherein there were 4 adults and 1 boy. And they went for a picnic on the high seas. The sea was choppy and they got lost and ultimately landed upon a no man's land. And there was no food to eat. So there are 4 adults and the small boy. And they had a very loud and a wise thinking that, do you know, in England, the right to private defense to the extent of causing death of a person is allowed. So you can kill the other person to protect your body. How it operates is a different question, but they interpreted it this way. Their interpretation was that we'll do one thing, we'll kill the small boy because right to private defense to the extent of causing death of a person is allowed. They cut the boy into pieces, fed on him, and after 7-8 days came back. When they came back to England, people asked them, where's the small boy? And everybody had a story to tell, what to tell you, and there was a storm and the sea was choppy, and then this and that and whatnot examples. Where's the boy? We ate the boy. I mean, we cut him into pieces and fed on him. Because, I mean, there's no other way. And right to private defense is allowed. All were tried for murder. Matter went to the highest court in England, and the lawyer who was representing them started arguing right to private defense to the extent of causing death of a person is allowed. Lord Denning, who was the then judge who was presiding, he said, gentlemen, hold your argument for a while. You just answer me one question. You 4 are stronger and the boy is weaker, so you killed him and fed on him as per your story. Forget the boy. 4 of you remain. And out of you 4, 3 are stronger and 1 is weaker. What would you do? So the strong, you are going to kill the weak, the 4th one, the weakest. For 15 days, again, there is no food and there are only 3 people remaining. Out of these 3, 2 are strong and 1 is weak. So you 2 are going to kill him. Then only 2 remain. Again, there is no food for 15 days. So what are you 2 going to do? You are strong and he is weak. So you are going to kill him. And what is the result? 4 people are killed as per this theory to protect 1 person. This is the fallacy in your argument. Whatever the employer does, it should appear as white, as broad daylight, but in the colorable exercise of the employer's right. So what is an unfair labor practice? That which is done not in good faith, but in the colorable exercise of the employer's right. What is colorability? Colorability is, it sprang up from a doctrine from the Supreme Court in n number of cases, basically Bennett Coleman and Company Limited or Sakal newspapers. And colorability is that which you cannot do directly, you cannot do it indirectly also. So if you can do it directly, it's okay. Otherwise, if you cannot do it directly, you cannot do it indirectly also. I mean, though this is the Bennett Coleman and Company case is a case from constitutional law, but as we understand, those of you all who are law students may be understanding it better, that newsprint was to be imported in India. And there were two types of newspapers, those writing pro-government and those writing anti-government. And the government came with a very flowery facade that we do not want to discriminate against anybody. Everybody is equal in the eyes of law and for the government also. So what they did is they distributed the newsprint equally. On the face of it, it appears when equality is being followed. But the problem was Times of India said my circulation is 30 lakhs of readers. And there were some newspapers who had only 3 readers on their account. So what will they do with with the newsprint? And Times of India or Sakal newspaper say, I mean, this newsprint is not even enough. So there should be a nexus with the number of readers rather than just distributing the newsprint equally, which was to be imported. So that which you cannot do directly, you cannot do it indirectly also. We proceed further, friends, by falsely implicating an employee in a criminal case on false evidence or on concocted evidence. By falsely implicating an employee. Yes, criminal case, so that he faces the music. I mean, this has been, you have seen all of these things in Hindi movies also, that there is a villain and he plants something in the cupboard, and then who's taken it, and he's planted it very slyly and intelligently in the cupboard which belongs to the hero. And he is caught, police are called, and ultimately he is implicated. It reminds me of a story, friends, before I proceed. And the story is written by nobody else but Mohandas Karamchand Gandhi, that is the father of the nation. But why I'm telling you this is, he's narrated it in his book, The Story of My Experiments with Truth. And at that point of time, he was not Mahatma, he was Mohandas Karamchand Gandhi. And Mahatma Gandhi writes that I went to school. And in school, there are all sorts of boys and girls. In school, there was somebody who stole somebody's pencil. And the teacher said, who's stolen the pencil? Mahatma Gandhi said that I told the teacher, my mother has taught me to speak the truth. And the truth is, I have not stolen the pencil. The teacher demanded an inspection. So everybody's bags, school bags, were examined. Now, whoever was the thief, he took the pencil and put it slyly in Mahatma Gandhi's bag. When the inspection was done, the pencil was found in Mahatma Gandhi's bag, and the teacher again demanded an explanation. Mahatma Gandhi said, the truth is, my mother has taught me to speak the truth. I have not stolen the pencil. This is the truth. The second truth is, the pencil is in my bag. I can see it. And the third truth is, I don't know how it is in my bag. I told you, he was not Mahatma at that point of time. He was just Mohandas Karamchand Gandhi. The teacher punished him. Mahatma Gandhi writes in his book, what was I to do and where was I to go? I came home, I cried in deep anguish. And it was in the morning I calculated that a man of truth has to be a man of care. Remember, friends, being truthful is not enough in this country. You have to be careful also. Somebody, in the course of my practice, there was a chief financial officer, and he said something which I still remember it. It's already etched on my brains. You have to remember one thing, relations in this world, not only in India, are based on mutual distrust, especially when people work in organizations or schools and colleges and companies and anywhere. Relations between people are based on mutual distrust. I don't trust you, you don't trust me. If my signature is there, yes, the file is with me. If it is not there, then it is with you. The truth could be different also. But then, again, we understand to falsely implicate an employee in a criminal case on false evidence or on concocted evidence, you concoct the evidence, create the evidence. And then there are people who play pranks, and then some are very well versed at all of these things. So to implicate an employee in a criminal cases, there are so many criminal cases, some are cognizable, some are non-cognizable. Section 420, cheating and dishonestly inducing delivery of property. 378 is theft. You take something belonging to the company, and there's a changing room where all the workers change their clothes, put on their uniforms, take something belonging to the company, put it in his locker, and then the locker is shut up. Then, I mean, there's an inspection. Again, the thing is found. But what is this? The employer has falsely implicated him in a criminal case, and the evidence which is there is a false evidence. Okay. Then further we go for patently false reasons. Now you see, the false reasons are qualified by an adjective, that is patently. What does this mean? Patently false reasons. There are so many answers to it. Totally false reasons. You tell a manager, just catch hold of some worker and then indulge into hand-to-hand scuffle. Let him be your sparring partner. And then 3-4 people see it and then put up a charge on the worker that you are beating the manager. Come on, prove it, disprove it. Many a times we have seen that workers, sometimes while he is resting, you click photographs and then you say that you were sleeping while on duty. Again, patently false reasons. Remember, friends, for all of these, whatever I am talking, there are not one, but umpteen number of case laws. But then my time, as I told you, is very limited. And we are yet to go further. Okay, next is untrue or trumped up allegations of absence without leave. What are untrue? First is untrue is false. You understand this. Trumped up allegations of absence without leave. Now you see there are many time machines. Once upon a time, you had a punching card. Then came some magnetic card. You just have to swipe it and your attendance is recorded. Then, I mean, I give my card to somebody else, so I need not be present. So people started playing mischief. Students many times give proxy attendance in classes. So this started happening. So how do you ensure attendance? So likewise, today we have a technique that is the biometric technique. Biometric is that you just give a thumb impression, and it's based on a presumption that no two people on earth have the same thumb impression. The grooves which are on your thumb, everybody's grooves are different, and that's what is the beauty created by God. I mean, how could he have so many variations? That every person staying on earth has a different thumb impression, but yes. But our scientists have made use of this, and ultimately we have the biometric machine, which possibly you must have seen in your companies or schools and colleges and at a number of places. Now what happened is that you just have to come give in your thumb impression and your attendance is recorded. Trumped up allegations of absence without leave, and then there's an instance where a worker used to come in the morning, 8 o'clock is the shift, and by the time he used to give his thumb impression, the management, that is one of the managers, called him. Said, you do one thing, forget about that thumb impression, you are already present. You do one thing, right now you are going to the railway station and booking a ticket because the managing director is traveling here and there. And then likewise, he made him go there n number of times. And the worker also failing to understand that his attendance is not recorded. And ultimately, his attendance was not recorded when it piled up and he was given a charge sheet that you are absent. And under the charge sheets, under the misconducts, that is, for your information, friends, misconducts are spelled up in another legislation, which is called as Industrial Employment Standing Orders Act 1947. 46. Under this, standing orders means rules which apply, and not to adhere to the rules makes a person guilty of a misconduct. Under which there are two types of rules. One are model rules, which are called as model standing orders, and one are certified, that is ready-made rules. We are not on that. But then there are almost 26 misconducts. Theft is a misconduct, riotous behavior is a misconduct, insubordination, not to listen to the superior, that is a misconduct. Then, as I told you, habitual absence is a misconduct. Absence for 10 consecutive days is a misconduct. Overstay of leave is another misconduct. I mean, so likewise, then the latest being sexual harassment of women at workplace. There are almost, I mean, 26 misconducts totally, if you count. And then if somebody engages into this sort of a misconduct, yes. But what about if he's not done it and he claims to be innocent? And then what you have done is you have made untrue or trumped up allegations of absence without leave. And this person was present every day. And then the proof comes, the proof is very important. So where's your thumb impression? Come on, let me see the biometric codes. And there is nothing. And then this is safely, one can conclude or even the court can conclude if this evidence is filed in the courts of law that he is absent. In one company, I remember the company knew the software people very well, and they even went to the extent of erasing those codes. And I'm really at pains to understand whether this could really be done. I mean, I'm not a technical person. So, but then the point what you are discussing is that untrue or trumped up allegations of absence without leave. So, leave, friends, here is in the sense of a permission. If you want to go on leave, whether it's under the Shop Act or under the Factories Act, you have to apply for the leave in advance. Then, friends, I go further. In utter disregard of the principles of natural justice in the conduct of domestic inquiry, or with undue haste. Now, what is a domestic inquiry? Madam Bhandari just now said that, yes, my doctorate is in domestic inquiry. Domestic inquiry is a mission into the truth. I told you there are so many misconducts. And if at all a worker has indulged into a misconduct, the management alleges misconduct against him. Say, for example, you are drunk while on duty. Saying is not enough. You have to prove it also. So then there is a method of proving. A charge sheet has to be given. An examination in chief has to be put forth. Then there must be a cross-examination. Right of to be heard should be given. And all it's a long drawn-out procedure. In utter disregard, remember, disregard is qualified by an adjective that is utter. So how should the inquiry be? It should be in utter disregard of the principles of natural justice. Means what? To give him a vague charge sheet. Again, that is not allowed. Then you say there are so many instances, documents are not given, documents are in the custody of the management, and yet you don't produce it. Don't give him time. Conduct the inquiry in undue haste. Morning you give the charge sheet, afternoon is the inquiry, evening 5 o'clock he is thrown out of his job. You hold the inquiry in disregard of the mandates which are given by n number of judgments by the Honorable Supreme Court and the High Courts. So likewise, there are so many. I mean, I'll tell you the vistas of this. The traverse of this subject is too great. Just to pinpoint, there are 475 cases cited by me, Supreme Court and High Court, in my thesis itself, only on one word, that is domestic inquiry. So you can understand as to what is. So each and every aspect of inquiry is to be tested on the anvil of whether this is cogent proof, or whether it shocks the conscience of a legal man, whether it speaks of natural justice. And natural justice, friends, as you know, are two in number. One is audio alteram partem, that is right to be heard. And second is enshrined in a maxim, that is nemo debet esse judex in propria causa, that is nobody can be a judge in his own cause. Now you don't adhere to any of these things. You don't give him a hearing, so that is utter disregard of the principles of natural justice. The inquiry ought to be conducted by an impartial person. You don't appoint an impartial person. See, Lord Denning has said that justice is rooted in confidence, and confidence is destroyed when right-minded people go away thinking that the judge was biased. So the judge, like Caesar's wife, should be above suspicion. Otherwise, what you get from the court of law is a decision and not justice. And people come to courts of law for justice and not decisions. Now you see, the sentence is only one, but so much of a meaning it carries that it should, if at all, to discharge or dismiss employees in utter disregard of the principles of natural justice in the conduct of a domestic inquiry or with undue haste. Sometimes managements pressurize the lawyers who are into this business of conducting inquiries that enough of it. Come on, enough of this person. Morning 11 o'clock, give him a charge sheet. Afternoon, you conduct the inquiry. Evening, we'll throw him out. No, there are a number of authorities of the Supreme Court of India. How much time you should give to a person between two transactions? And the answer, safe bet, is 24 hours. 48 hours at least. Hemchand versus Union of India. So many judgments are there. Okay, friends, we go further. For misconduct of a minor or technical character without having regard to the nature of the past record of service so as to amount to a shockingly disproportionate punishment is an unfair labor practice. Now, what's the unfair? For a misconduct of a minor or technical character. Say I say you are absent on 15th of July and that's why we are going to dismiss you. Half a day absent or 1 day absent, and if you are going to dismiss people tomorrow, I mean, why half? Full India will be on the roads. Because the answer is very simple. Sometimes you fall ill and sometimes I fall ill. Sometimes you are sick and sometimes I am sick. And sometimes you have got social obligations and so do I. So for 1 and 2 days, if you start dismissing people in this country, how will people live? And this is for everybody. So for a minor or technical character, without having any regard to the nature of the past record of service, past record is very important. And the model standing orders, what you have to see, are aggravating and extenuating circumstances. Means what? That this person was warned 5 times for late coming, then he is say suspended 3-4 times, then his increments were stopped, this that 7 punishments were given in the past, and even today he is doing the same thing. So the last straw will break the back of the camel. So one day it comes. Of course, you have to remember one thing, that you cannot punish any worker for past misconduct. The punishment has to be on the present misconduct only. The past misconduct will weigh the thing. I mean, whether it will aggravate the thing. You see, there is a habitual offender, and ultimately we say you are a habitual offender. You have done it again and again and again. So how many times should we pardon you? Just yesterday, there was a management, and they admonished one worker for being drunk on duty. And all the while, and the worker is such, I mean, he cries and weeps and that, this and that, and he accepts everything. Yes, sir, I was drunk, and aage se aisa nahi karunga. And this has happened almost 7 times. And even yesterday, he was just rolling on the floor and saying, "Ke maaf kar do and galti ho gaya, and abhi aage se I am not going to drink anything." I mean, how many times? But you see, nature of the past record of service so as to amount to shockingly disproportionate punishment. You are absent on 15th of July, so you are dismissed from service. Yes, there could be a bit of a fine fluid difference, that sometimes one management may warn him, the second management may suspend him for 2 days, and the punishment, I mean, the line is very thin. For which, friends, there is a principle which is evolved in England by Lord Green, and that principle is called as the Wednesbury principle. Wednesbury principle means it's for the administrative authority to decide as to what could be the punishment. He can be warned also, he can be suspended for 1 day also. For that, the punishment should suit the patient, the medicine should suit the patient, something like that. And if at all it is shockingly disproportionate, means what? It shocks the conscience of a reasonable man, then it is an unfair labor practice on the part of the employer. We proceed further, friends. Item number 2. Now you see, these items are triable by the industrial court. To abolish work of a regular nature and to give it to contractors as a measure of breaking a strike. There are many companies, time and again, if at all, they enter into this sort of a situation wherein their workers go on strike. So what they do is to abolish the work of a regular nature and to give it the work to contractors as a measure of breaking the strike. They tell their workers, you want to sit on strike? Sit till doomsday. Sit till the last day of this earth. We are not going to talk with you. And what do? We'll bring a contractor, contract labor, and get the work done. See, if this is to be done, then the very essence of going on strike is lost, and which is not allowed. So if at all an employer, you have to talk with your employees only. You cannot say that I'm not going to talk with you. The strike, I mean, you may be successful in handling the strike, unsuccessful in handling the strike, whatever. I mean, in negotiations, you can win, you can lose. The workers say we want 46,000 rupees rise, 35,000, 1 lakh, whatever. And you bring them down to 20,000. That is your skill in negotiation. But you cannot say the workers are on strike, let them go anywhere and let them be on strike, and I will bring in a contractor and get the work done. This is not allowed. So to abolish a work of a regular nature and to give them to contractors as a measure of breaking a strike itself is an unfair labor practice. Again, there are so many ways and means for this. Third item is transfer from one place to another under the guise of following a management policy. This I just now told you. To transfer an employee mala fide. Mala fide is an antonym of bona fide. Bona fide speaks of good faith. We always say, what are your bona fides? So what are your merits? So this is an unmerited transfer, and the company, I will not paint everybody with the same brush, but then some managements are very unscrupulous. What they do, this make a who's who of the employee. that he is in Pune, and then his family is in Pune, and his great-grandmother is in Pune, and his father is in Pune, and everybody is in Pune. Children go to some school, and wife is also employed in Pune. And what they do is they make totally a show off, and then outwardly put up a very saintly front, and then issue him a transfer order that your services are required in the best interest of the company at, say, Kolkata. So if the worker stays in Pune, his services are required in Kolkata. And if at all everything is in Kolkata, then his services are required in the best interest of the company at Pune. This is done purposely. Of course, there are other means, that is, in the appointment order, the job should be a transferable one. And then some companies, what they do is, we remember there was a company, it transferred that employee from Pune um, settings in Pune, that is his wife school and college, and everything was in Pune. So this poor person had to be at Kolkata. Very wrongfully, they terminated him. They terminated him in Kolkata. Now his problem is, in order to file a complaint there, for after every 15 days, he will have to do shuttling from Pune to Kolkata. And with whatever, he's already out of the job. So whether he can afford it. And this was done purposely by the management. It's like, see, fighting with a crocodile in water is a different thing, and fighting with the same crocodile on land is a different thing. Circumstances change, parameters change, strategic positions change, and this is what exactly was done by the management. This person having no place to stay in Kolkata, again came back to Pune. Now go and file a case in Kolkata again, and then after every 15 days ensure that you are in Kolkata, and that too without money. So all this becomes difficult. To transfer an employee modified from one place to another is under the guise of following a management policy is an unfair labor practice. Then is to insist on individual employees who are on a legal strike to sign a good conduct bond. Friends, what is a strike? Strike is defined in Section 2Q of the Industrial Disputes Act. Strike is a total cessation. Cessation, the word comes from the word cease. Cease means to stop. It's a total cessation of work by a body of persons acting in combination or a concerted refusal under a common understanding. See, all these ingredients should be present. And what is a legal strike? If you see Section 22 and 23 of the Industrial Disputes Act 1947, that's the central act, which defines as to what is when the strike would be an illegal strike. That you have to give a 14 days notice, then you cannot go on strike before the date which is mentioned in the strike. And what you do is to insist upon individual employees who are on a legal strike. If a notice is also given and all four corners of the law are followed, the strike happens to be a legal strike. Different strikes are there. We have a general strike, and we have a pen down strike, and we have en masse casual leave, and we have a hunger strike, and we have a go slow, and then we have a lightning strike, and we have a quickie strike. But the point is, they should be a legal strike as a precondition of allowing to resume work. I mean, childhood, that whenever to err is human, and as a child, I was prone to make so many mistakes. I mean, sometimes I look at my childhood, it's full of mistakes only. And in my house, the answer was simple. I mean, the answer to this was very simple. Whenever I made signed good conduct bonds, that henceforth my behavior will be good. And then only, I mean, I got the original status in my house itself. But friends, we are talking in terms of unfair labor practices. To insist upon individual employees who are on a legal strike to sign a good conduct bond as a precondition to allowing them to resume work is an unfair labor practice. No. Section 114 of the Indian Evidence Act 1872 says, say everybody who is listening this webinar and seeing this webinar is good till it is proved that he is bad. Everybody who is looking at all these things, I mean, in the webinar, is sane till it is proved that he is insane. Everybody who is in this webinar is honest till it is proved that he is dishonest. So some presumptions will go. And the presumption is not a negative one. Presumption is, yes, everybody is good. So all workers are good. But you cannot ask a good conduct bond. If at all he behaves erratic tomorrow, commits some misconduct, you conduct an inquiry, throw him out, whatever options are available with you under the law. But you cannot ask an employee who is on a legal strike to sign a good conduct bond, because everybody's conduct is presumed to be good, unless it is proved that he has a bad conduct. Then you see, friends, we have to show favoritism or partiality to one set of workers regardless of merits. Now, this is very important. Favoritism. Let me tell you, favoritism has existed when man stayed in the jungle, and it is going to be there till the last day of this earth. There will be favoritism. So what you can do is you can minimize the favoritism. And if at all this is as open as broad daylight, then it's an unfair labor practice that you favor somebody and don't favor somebody. In all these companies, there's a word which is very fashionable, I would say. It's in vogue. And the word is SOB. SOB means son of the boss. He is never late. He is stuck in the traffic jam. You are always late. He is not inefficient. He is overburdened with work. You are lazy. You are slow. You don't understand the work. He is not that way. Why? Because he is connected with the boss. Son of the boss, SOB, is going to be there when man stayed right from the first day that's in the jungle till the last day or till doomsday. You cannot eliminate favoritism. It's like something like saying you can eliminate sexual harassment at workplace. No, you can minimize it. I mean, there have been so many judgments to that effect. To show favoritism or partiality to one set of workers regardless of merits. Now, this word is very important. Regardless of merits means if at all there is a merited classification that is allowed. I'll tell you how. I remember there was a company wherein half of the workers' provident fund was deducted at 12% of their basic and dearness allowance of the wages. Salary contains 4 components basically. One is basic wages, one is dearness allowance, which in the vernacular is called as the Mehengai Bhatta. Then is house rent allowance, and then there are other allowances. What happened is the deduction today, as per the Provident Fund Act 1952, is 12% of the employer share and 12% of employee share. Some half of the employees, as far as their pay packets were concerned, their provident fund was paid at 12%, the remainder was paid at 14%. I mean, forget that illegality and whatnot, but I mean, just we are on the point of the differentiation. You have to have the same yardstick with everybody. And why should you be doing it with some people? You show partiality to one set of workers. Sometimes a person who comes late 4 times within 1 month is declared to be a habitual latecomer under the misconducts. You come late thrice, you are marked late, and you are declared to be habitual. Only 3 times, not even 4. And some people come late 12 times and nothing happens, because this is partiality to one set of workers regardless of merits. Regardless of merit is meritly you can do it. Say for example, a wage negotiation was going on, and what is the increment to be given? So people who have completed from 0 to 5 years, 1 increment, 5 to 10 years, 2 increments, 10 to 15 years, 3 increments, and 15 to 20 years, 4 increments. So here the differentiation is because of his experience is more. He is 15 years in service. So naturally he is to get more. So this cannot be something which is distributed devoid of merits. There is some merit to it. But to show favoritism or partiality to one set of workers regardless of merit, this basically happens when 2 people fight and one person is charge sheeted and the other person is not charge sheeted. See, there is a hand-to-hand scuffle between 2 workers, which may be a normal scene in any company. And one day, one is only charge sheeted and one is only taken to task, whereas the other person is also equally indulged in the fight. So his contribution to that act is still the same. But he is given a clean chit and not even charge sheeted. So he may accuse the management of showing favoritism or partiality to one set of workers regardless of merits. I remember, friends, that when I was in school, my grandmother used to tell me a story. that there used to be a king and he had two wives. I presume bigamy was allowed in ancient India. And these two wives, he used to love one and hate the other. So as a child, I used to always think, then why did he marry? But then, this is a story. And in every story, this was the common denominator, that there used to be a king and he used to have two wives and he used to love one and hate the other. But then if you see, psychologically, this is possible also. And then sometimes you see, you like a person for no reason and you hate a person for no reason. There are 17 examples which each and everybody of you might be having. One day I remember I was caught by a policeman at a signal and I was on my motorbike and he asked me my name and I told him Shrikant. And his name was also Shrikant. And he fell in, he said, no problem, you can go. There's no reason. And same is with hatred also. So this favoritism thing is very complex to understand even psychologically. Next we go further, to employ employees as budlies, casuals or temporaries and to continue them as such for years, with the object of depriving them the status and privileges of permanent employees. Now what happens is, in India, this getting permanent in service is a big phenomenon. Some years back, I went to my village and there was a village elder man who was distributing wedding cards. And he gave me one wedding card. I opened it. It was a usual wedding card. The name of the bride was written, the name of the groom, the would-be husband, his name was also written. But my eyes stuck up at something different. Below that bridegroom's name, it was written permanent in service on the wedding card. I just raised my eyebrows, looked at him. And he said, yes, my would-be son-in-law is permanent in service. That's why he's printed it on the wedding card itself. It appeared very clear to me, but for a moment, I just stepped into his shoes and started looking the thing from his point of view. And he appeared more right to me. That yes, India is a country when there is rampant unemployment, and this person has got not only his daughter is getting married, he's got a son-in-law who's not only having a job but is permanent also. And this is some time for him to rejoice. And that's why he's printed it and everybody is to join the Gaiety. I looked at him, I said, yes, he appears more right to me. But you see, to employ employers badlis, there are people. Badli means what is a substitute? Iske badle mein wo. So you go to any company, they say that, okay, this driver is not there. Uske badle mein you will work for one day. When he comes, you again go home. And this badli, substitute, it goes on or casuals or temporaries. So you are a temporary person and you are a permanent person and you are a substitute. In sugar industry, still further classification. You are a seasonal employee. Means he comes from season to season because sugar cane is a seasonal crop. And what is the unfair labor practice? To continue these people, that is badlis, casuals, for years together. Years means how many? In 1 year, there are 365 days. So 730 days is 2 years because it is plural. And with the object of depriving them the status and privileges of permanent employees. There is a judgment by Honorable Justice S.B. Sinha of the Supreme Court of India, that is Gangadhar Pillai versus Siemens, wherein he has emphasized upon these words, with the object of depriving them the status and privileges of permanent employees. What is with the object of? So your object should be, I keep him again, come again and again and again. Or I have stretched his service to such an extent that he never becomes permanent, to deny him, depriving them of the status and privileges of permanent employees. At some places, there are project employees. He lives only during the duration of the project. So his services, he lives with the project and his service dies with the project. And then there were some people, the project lasted for 15 years and one day the project was over and they were asked to go home and they said, this is an unfair labor practice because we were just kept temporary. In fact, we have already become permanent, but permanent where? You have become permanent in the project. So all these things have to be weighed. Then we go further, friends. To discharge or discriminate against any employee in filing charges or testifying against an employee in an inquiry. Now you see, or proceeding in relating to an industrial dispute. There are two workers and they indulge into a fight. Simple example I'll give you. They indulge into a fight and one of them, there's an inquiry and he says, I want to cross-examine the other worker because he was also there, or I want to bring him and I want to produce his testimony as my evidence. And the management tells him, "Nahi, you're both busy, he cannot come here." And to discharge or discriminate. So management is discriminating against the employee for filing charges or testifying against an employer in an inquiry. Or sometimes, if you speak something against the management in any inquiry, you will be discharged or you will be discriminated against. The moment you open your mouth against the management, this is an invitation for any harassment. And if you are working in such managements, then you don't require an opponent. You have already been jinxed. The moment you have joined this sort of an association wherein people, just because you spoke here and there, you spoke the truth, that is understood. So if you have testified against an employer, if you have deposed against an employer in a departmental inquiry or in any proceeding relating to an industrial dispute, you come to the court of law, the judge makes you enter the witness box. Needless to tell you that under Section 3 of the Indian Evidence Act 1872, what you depose in the box is a piece of evidence. And you have testified against the employer, and the moment you go to the company back, your discrimination starts. This itself is an unfair labor practice. Then is to recruit employees during a strike, which is not an illegal strike. To recruit employees during a strike, which is not an illegal strike. Now you see, not an illegal, two negatives. So it means which is a legal strike. So while a legal strike is going on, you cannot recruit employees. Otherwise, the very essence of going on strike, you remember, is the last weapon in the armory of labor. And lockout is the last weapon in the armory of the management. Or rather, lockout is an antithesis of a strike. The answer of the employer for a strike, his ultimate answer is lockout, not that he is going to bring some 10, 20 gundas and you have to ensure that yes, everything is going smooth and you have to employ other employees also. That is not allowed. So to recruit employees during a strike, which is an illegal strike, which is not an illegal strike, we have 5-10 minutes and then I'll immediately complete. Failure to implement award, settlement or agreement. What is an award? Award is defined under the Industrial Disputes Act. It's a judgment when a reference is declared and the award is declared, that is, the judgment is ultimately delivered. Settlement is under Section 2P of the Industrial Disputes Act. Or agreement. What is an agreement? Agreement is much more wider than it appears. Your appointment letter is also an agreement. Read with the standing orders put together also amounts to an agreement. There have been a number of cases, right from CIPLA to so many of them. But then I told you the time is quite limited. Failure to implement award. So anything which deviates your service conditions is failure to implement award, settlement or agreement. The best example I can give you is during Corona. Say a person is appointed in a company, his wages are 10,000 rupees per month. And during the lockdown, the sales have plummeted. The total business is on a downhill. It's landed up in the waste paper basket. So the company says we cannot pay you this much. So instead of paying you 10,000, I pay you 7,000 rupees only, 3,000 less. Now this amounts to be an illegal deduction under Section 7 of the Payment of Wages Act 1936. But what ultimately are you doing? Are you implementing any award, settlement or agreement? Your agreement is, in this case, that you will be paying him 10,000 rupees per month. Have you paid him? No. Reasons could be something else. Yes. But on the face of it, you have paid him only 7. So you have not implemented the agreement. Award is whatever is settled by the court. That is what I told you. Award is a definition. Settlement is, you must have read it in newspapers that this union and this management, they had a very handsome sort of a deal and a win-win situation, and the wage negotiations are over and everybody is happy and there cannot be a negotiation better than this. And then you see photographs clicked and then they shake hands and smile at each other and so many of these. settlement. Settlement is a registered settlement. It has to be registered with copies given to the respective authorities mentioned. Okay. There is a judgment by Honorable Justice Dr. Saraf, wherein he says that if the copies are not given, you have not not followed the law in letter and spirit, so that cannot amount to an agreement itself. So all these things will have to be taken into consideration. And lastly, to indulge in any act of force or violence, this A should not be capital. Okay. Anyway, so to indulge in any act of force or violence. Now, this is something added later. Later in the sense, till 9, all items I have read somewhere that they were ready, but then Maharashtra government added the last one, maybe due to the muscle power or the mafia dons who sometimes are found in the in such areas, not all the while, but then yes, such things also cannot be ruled out. Management should not hire gundas or sponsor muscle power just because they have money and throttle trade unionism or any indulgence of act of violence. And then you cannot allow any strike to be hijacked by mafia goons. So all of this, it would amount to violence. And apart from this, any act of force or violence, violence could be mental violence also. It could be physical violence also, but we understand it more in terms of physical sense right now. And then if at all the management indulge into all of such things and then indulges into an act of force or violence, that again is an unfair labor practice. Okay. Friends, I'm talking since almost an hour, and we are almost exactly on the hour, and my time is limited. Otherwise, there are so many example stories, case laws. I can go on and on and on, but then there is time for me to stop also, and I have to answer your questions also. Okay. So it was nice talking to all of you. And then I tried my best. My humble endeavor was to comprehend the total unfair labor practices in Schedule 4 of the MRTU and PULP Act. That is the unfair labor practices on the part of employers from item number 1 to item number 10 in whatever is the possible time, that is 1 hour. Okay, so it's been a delight to come and talk to all of you all, and a big thank you to Bharati New Law College. Okay, yes, so I will not now stop sharing this, as I have to answer your questions also. So I will be, I have stopped sharing the slides. Okay, so yes, thank you so much. Yeah.
Thank you, sir. Thank you very much. Let me confess that the unique way in which a historical perspective, peppered with your experience and wide knowledge on the subject, has truly made this webinar a lifetime experience for all our viewers. Sir, we are actually flooded with questions in light of this amazing exposition on your part. So the first question is, it is really difficult to raise the voice against the authorities who are in higher position, as it can affect the promotion and also the job. So how can we deal with this issue, sir?
Now see, there are basically two types of people who work in any organization. One are managers and the second are workmen. For workmen, it's pretty simple. Section 2S of the Industrial Disputes Act 1947 defines who is a workman, that is, who does manual, skilled, unskilled, technical, clerical, operational work. I presume he is a workman. I presume, that's missing in the question. So, but I presume if at all he is a workman, then the answer is that you have to band yourself into unions. Unity is strength. We have heard all such stories since childhood. Then if at all you want to still have some further clout as far as unionization is concerned, then maybe you can have an affiliation with a stronger union also. There are so many central unions are there, Hind Mazdoor Sabha, and then INTUC is there, and ITUC is there, and so many of them. ITUC is All India National Trade Union Congress, which is communist. INTUC is Indian National Trade Union Congress, which is has a Congress ideology. Likewise, BMS is of Bharatiya Mazdoor Sangh, is of BJP. Likewise, but these bigger unions can give some sort of infused power in these smaller unions. But one thing is their unity is strength. If you go single-handedly, then it becomes easier for the managements to victimize you, to have a cherry picking, throw you out of service. And the rest of the answer, which the question, the rest of the question is, That how can I go against the management? Well, this is a universal phenomenon. On the one hand, you will be having managements, unscrupulous managements, muscle power and mighty and money and this and that and all of those things. But this is the way the game is to be maneuvered. That's why once upon a time, there were no unions itself. Mahatma Gandhi led the Buckingham and Karnataka mill strike in those days. And then there were no unions. People were imprisoned. That is the total. I mean, we have a galaxy of leaders, right from Manvendranath Roy and nobody else than Mahatma Gandhi himself. Then George Fernandez, so many of them. I mean, they have sacrificed something, so it requires something. But just an answer, a quick answer to what your question is, then it's in the fitness of things to get banded into unions. That will at least scare the managements a bit from at least indulging into any sort of unfair labor practices. Yes.
Precisely, sir. Precisely. So the
Yes,
next
yes.
question is,
Yeah.
how do we distinguish merited classification and workplace discrimination? Is there a certain process or rule book?
Your voice was getting cut. Can you please repeat it?
Yes, sir.
Can you
Sir,
please
the
repeat it? I mean, I couldn't hear you properly.
So the question is, how do we distinguish merited classification and workplace discrimination? Is there a certain process or rule book?
The process is very simple. First is, I mean, you have to adhere to certain rules. As I told you, there are two types of rules. Rules are called standing orders technically, and they are framed under legislation which is called as the Industrial Employment Standing Orders Act 1946. There are two types of rules. During the course of my talk, I did make a mention. One are model standing orders, that is model rules. Model rules are applicable in state of Maharashtra where the number of workmen are more than 50. See, I'll make it very simple. You are born in India, Indian Penal Code automatically applies to you. You didn't send a letter to the government of India saying that apply Indian Penal Code to me from today. No. Moment you are born, Indian Penal Code will apply. Likewise, in state of Maharashtra, the moment the number of workmen I would say, cross 50, automatically model standing orders apply. And then certified or ready-made standing orders that say, I mean, these are the deviations from the model, but for which you have to get it certified from the Commissioner of Labor. And then under section 13B of the Standing Orders Act, you have to get it notified also. Then they become rules. So certified rules, notified rules. Now, first is the question, merited and unmerited classification. First is you have to go by the rules. Anything is which adheres to the rules is merited. See, a promotion policy, you have a policy. Policy is agreed. Policy is a part and parcel of your rules, for example. Not to follow the policy is unmerited, but to follow whatever is stated. Say, for example, I remember having argued a matter wherein there used to be a rotational transfer after every 3 years. And then it was found that some people were just, warming their chairs for 14 years without a transfer. And some people were transferred after every 6 months or 8 months. So this is all unmerited. So the answer is that there must be some positive yardsticks, some real positive index, which are the rules. And non-adherence with the rules or deviation from the rules itself, you have to explain the deviation. Then it becomes unmerited. Yes.
Very comprehensive answer to the question, sir. So the next question is, the biggest killer is the Industrial Disputes Act, which says that if you are a manufacturing firm with 100 workers or more, you cannot dismiss any of them under any circumstances unless you get prior approval from the government. Do we need to change it, sir?
Yeah, we are certainly going to have labor codes wherein labor codes, I am saying, CODAs, which are on the horizon. The rules are yet to be framed, and that's why they are not implemented as yet. But when the Industrial Disputes Act was passed, earlier this figure of 100, that is what the gentleman who has given this wants to say is that application of Chapter 5B. Chapter 5B applies today after 100 workers. That is, after 100 workers, if you want to dismiss, if you want to retrench, you have to take government permissions. If you want to close down an industry, you have to take government permission. Now, this is not necessary if the figure is less than 100. But if you see, the original figure in the Industrial Disputes Act was already 300. It is brought down to 100. And in the labor codes which are coming, it is again going to be taken to 100. I believe the gentleman also expressed that this is a killer or something. I mean, that it pinched me. The word was, it's a killer act or something. No, I don't subscribe to this view. It's not a killer act. In fact, it's made by during the days of the Congress government, but it's a well-balanced act also. And then the labor codes which are coming are going to still achieve a better balance, because in these 70 years, we are having a deluge of judgments, minimum wages and payment of wages. So taking lessons from all these judgments, some refinements have been made in the labor codes also, okay, which are yet to come. We are not on that point. The question is that the rationale ultimately, see, unions have a demand to bring this figure to 50, and managements have a demand to raise this figure from 100 to 300, and both are justified. It's only a point of view which they have. But I believe this is well taken care of. See, if it is more than 100, 100 is a lesser figure. If it is at 100, it covers 70% of the Indian industries. But if it is at 300, it will cover only 20% of the Indian industries. So it's a free way, or an open area which is given. But then the unions accuse the management that if at all you bring it lesser than, or if you raise it till 300, there will be an anarchy as far as the industrial climate is concerned. There is some sense in that also. So you have to have a proper vigilance. That is more important. And then the figures. But now, as I understand, the codes are yet to be operative. As I understand, they have raised it to 300 workmen. That is the application of Chapter 5B. Yes.
Yes, sir. So an associated question with the labor codes, the consolidation of various labor laws into 4 specific codes has been pitched as a game changer for the new India. How prolific do you see the significance of these codes?
The time only is going to decide, but as I see as to how they are passed, and I have gone through them, there are some innovations made. Say, for example, some new types of workmen. Earlier, there were only 2 categories. Or even when one of the questions I said there are only 2 categories, managers and workmen. Even today, Section 2A says whoever does manual, skilled, unskilled, technical, clerical, and operational work is a workman, to whom the Army, Navy, and Air Force Act does not apply, whose wages are less than 10,000 rupees, and who basically is not a manager, is a workman. Only these 2 categories. But in the new laws, that is the labor codes, we are going to have gig workers who are different. We are going to have platform workers who are going to different. And I also learned that some managers are also going to be included in the definition of workman. There is going to be a special court also, so you can sell your skills better. And you see the economic setup of India and the world, liberalization and all those things were different in 1947. Some of the ideas were not even non-existent. And today the ideas of trade are also different, and technology has taken over. In those days, say in 47, you write a letter which reaches Brazil after a month. Today, in a second, your email is from here to any nook and corner of the earth. In a second, you have the email. So all these systems and technology have changed things. So in this context, we will have to see all these labor laws also. Otherwise, you see, I come at 18 years, I join some company, 18 years and 240 days, say under Section 4C of the Model Standing Orders, after 240 days, I achieve permanency. So 18 years and 240 days, I become permanent. And on my 19th birthday, the company understands that I am a good for nothing fellow. I'm totally inefficient. And they have to carry my economic deadweight till I retire, till the age of 60. Can't I do something? See, I am a carpenter, for example, and I have skills. I sell you my skills for 5 years. Pay me according to my skills. So these are some of the new areas which are now being thought over in the labor codes. Yes.
Yes, sir. I know, sir, we are actually flooded with questions, but I guess we have space for just one more question, sir. So one of the primary facets of a gig economy, sir, as you rightly pointed out, is the rising number of contractual workers. Sir, what are your views on this particular issues, and how do you think their interests can be best served?
Contractual workers, see, Honorable Prime Minister Narendra Modi ji is doing the globe trotting here and there. Have you ever thought that there are so many industries which have already entered the Indian peninsula? Pune itself, there are so many German companies and American companies and Dutch companies, and this has added to the economy. The answer is very simple. We have the land. We don't have the money. We, in the sense, as a developing nation. We have the land, we don't have the money. Our people don't have jobs. Those people have the money, those people don't have land. So we invite them. It's some sort of a symbiotic association we have with them, that they come here, they have their industry, they take a bit of their dividend. Our people get the jobs, our people also get a share of it. Unemployment is also reduced, and all of those things. So these things will improve the situation, in my opinion. What was the further question you had? I mean, just continue the question again.
Sir, one of the primary facets of a gig economy is the rising number of contractual workers. So what are your views on this particular aspect, and how far their interest can be best served?
Now you see, now you see, American companies are here. There's a criticism that why does America come to India? Because America knows only one thing, made in America, or they love only Americans. Indian peninsular market, 136 crores of Indians, is too huge a market. So they come for the market also. That is okay. So they take their share, we'll take our share. But when they come here, they start up a company, and if each and every Tom, Dick, and Harry is to be enrolled on the role of the principal employer, and if everybody is to be made permanent after 240 days of uninterrupted service, and if it's such a big workforce, it's very difficult. I mean, I'll make up a bold statement that it's very easy to remove the Honorable Prime Minister from his office in India, but it is very difficult to remove a permanent worker. So nobody is going to take the risk to have all these workers permanently on their own roles. So what is the via media? Via media is that there is a permanent principal employer, then you have a contractor, then you have contract labor. Till yesteryears, the contract labor could file up a case against the principal employer and obtain a stay. And this equation was changed with the coming in of the Kalyani Steels case by the Honorable Supreme Court. Then we had the Coca-Cola case, then the Indian Seamless case, then Indraprastha Gas, and then so many of them. Today, contractor is the employer of the contract labor, not the principal employer. And all these companies who come to India, if you see the ratio of permanent is to contract labor, it is 70-30. So for 30 permanent employees, only there are 70 contract laborers who really do not have rights. There was a poem written by Gulzar, the famous Geetkar and poet. He said, "Is Bharat mein do Bharat baste hai." So there are two Indias in one India. Then I thought for it, I mean, what does he want to say? And then he sent is that, I mean, some Indians have been given a stepmotherly treatment. It's true. And who are those Indians? Those Indians are contract labor. For contract labor, you can pay them less. I mean, now they have changed the rules that for same and similar employments, you have to pay the same. But is it the practical reality? No. Contract labor is always a discriminated labor. Is he an Indian? Answer is yes. You are on the permanent roles. Are you an Indian? The answer is again yes. So why should there be a discrimination? Why should a stepmotherly treatment be given? If I am to take up the brief of any union, I will say there is no necessity of a contract labor act only. But of course, if the employers hear me saying this, they'll kill me. So, and we have to balance the economy, and that much of proliferation of permanent labor and permanent jobs and permanent, do you have that much money? No. Just the lockdown has, I mean, almost torn the veil. India's economy is really into shambles. Our Nobel laureate, I forgot his name, he just made a mention that yes. So all of these things, we have to see it in one bag and in one go. It's not that we see a part of it. So we have to see it in one go. In that manner, I mean, for that instance, if you remove the Contract Labor Act, why would any foreigner come here? No company is going to come. So we have to have a win-win situation. They also make a bit of a profit. We also make. Otherwise, we don't have money. I mean, It's very demeaning for us to call ourselves a poor nation. That's why we call ourselves a developing nation. But the answer is, I mean, we don't have that much money which those our counterparts have, that is foreign partners have. So this has to go on and on. And with technology, India can, I mean, we brag of that we have the largest scientific force in the world. More than 51 to 60,000 at 1 year were the new scientists which were coming. No other country has this much of a technological force. So with all these things, the future of India appears bright. Of course, we have our own problems. They are not hidden from anybody. But then this is all to be balanced. It's not an easy game, is what is the answer. So otherwise, if I belong to the union, I will say no scrap of the Contract Labor Act and everybody should be on the principal employer's roles. If I am an employer, I will say, no, enough of this principal employer thing. All employees, whoever I appoint, will be on the contractor's role only. So it has to have a balance also. You cannot scare the wealth creators. Ultimately, we also want to be rich. So you cannot scare the wealth creators who are coming to India. You cannot scare them away. Otherwise, they'll go away. And then you and your land and your rivers and trees and fruits, and what are you going to do only with that? There's a limit. There's a limit to that. So this economy, in order to have it a boost and a good momentum, you have to reboot it at n number of places, and then things can work. And then everybody, the trouble in India is that there are so many other questions also, which are more taking time, man hours, than what happens in foreign countries. Their automation is there. Under rationalization, you see with rationalization, a simple example I'll give you. Earlier in your office, you used to see 10 typists. Then you bring two computers with an Excel and a PowerPoint and Word, MS Office. Now, the work of 10 typists can be done by 3 people. What happens to the 7? They have to go home. What will they do? They are unemployed. So likewise, it's a balance. I mean, many things are there. Yes, this can go on and on, but I believe the time is limited. Yes.
Precisely, sir. Precisely. Thank you very much, sir. Let me tell you, every answer to the question was a resplendent elucidation in themselves, enlightening us about the various facets of labor laws. With this, we come to the end of this particular session. May I now request our student representative, Khushbu Chaudhary, to kindly give away the vote of thanks.
Thank you, Yash. Sir, I have to say that was an amazing session. You shared your insights through the case studies and the examples, and those helped us in understanding the concept so clearly. The way you explained how the situations are viewed from so many different perspectives and why the laws that are laid down help us lawyers in distinguishing them. That was enlightening, sir. And moving on to the vote of thanks. Today's fast-changing world calls for a close partnership between states regarding labor disputes. The study of labor law is one step towards the ultimate goal of making the country a workplace where the laborers can flourish easily. I hope this session and Sir's guidance will highlight these goals and help the students have a better understanding of labor law. Thank you, sir, and our Dean and Principal, ma'am. Thank you so much.
Yeah.
And Jayashree, ma'am. And thank
Madam,
you. Yes, ma'am.
Khushbu, madam.
Yes, sir, please continue.
Khushbu, madam, before I close, I mean, I want to say a big thank you to Dr. Ujwala Bindale, madam, as well as Jayashree Khandare, madam, also. So,
thank you so much, sir. It was really an insightful lecture for me. And I also learned many new dimensions of labor laws, sir. Thank you so much, sir.
Thank you, madam. Thank you, madam.
Yes, sir. In closing, I wish to express my gratitude to all the participants and the technical team for their full cooperation and contribution to this session. But before we